everyone, and welcome to another podcast by the Conflict Law Centre at War. Today, we are very, very happy to be joined by Dr. Richard Clements to talk about his fantastic book, The Justice Factory. Dr. Richard Clements is an assistant professor in international law, specializing in international law, legal theory, and international organizations. Thank you so much for joining us today.
Thank you.
So to start off with, and for the benefit of our viewers at home who may not have read your book, could you briefly explain your main argument?
Yes, so I just want to start by thanking you, Aisha, and the team for the invitation. And I'm really looking forward to having this conversation. So the book's argument, in very brief terms, is that management ideas and tools are very important in shaping the global justice project, particularly the ICC's version of that project, the International Criminal Court. And if I were to go into a bit more depth, I would begin by just saying that management tools and ideas are quite familiar, I think, to many people who work in large, complex organizations, whether that's the United Nations or even a law firm or other national bureaucracy. Particularly since the 1970s, we see this wave of management practices under new public management, as it was called. And these include things like strategic planning, auditing, performance indicators, performance appraisals, restructuring exercises. And at the International Criminal Court, these are very prominent. They've been there right from the beginning. And they, as you may have seen in the book, and certainly the book tries to show how they've expanded gradually across different aspects of the court's work. So the organization as a whole, but also in terms of individual professionals within the court, how they are also affected by these tools. And then lastly, the legal argumentation of the court, which maybe for the international lawyers out there is the most interesting, perhaps most concerning aspect of this phenomenon. And their two management ideas and tools have an effect on the jurisprudence of the ICC. So in many ways, management is shaping the priorities, the work, and perhaps even visions of justice that the ICC has.
Yeah, and I particularly love the part of the book where you describe former prosecutor Ocampo as having adopted the mindset of an entrepreneurial manager within a startup. And so this notion of the ways in which the neoliberal kind of speak has kind of encroached even on the International Criminal Court. So from what we've seen of the strategy papers coming out of the court since then, has this gotten worse under the new prosecutor, do you think? And do you think that the interests of justice are being further subsumed under this neoliberal spectre of managerial efficiency?
Yeah, so there's a couple of things there actually that you rightly kind of pointed to. One is that, the prosecutor at the time, Luis Moreno Ocampo, who's the first prosecutor of the court, was very interested in trying to think of the court as kind of as a startup. And to be quite honest, that didn't really work out very well because it's easy to have that mindset of leanness, flexibility, kind of rapid response when there aren't really very many cases. And of course, at the beginning of the ICC's work, there were really no cases for a while. And even then, they kind of came in a drip fashion. Later, whenever they ended up having more cases on the docket, they had to try and figure out ways of managing people, managing workflows, and making sure that all of these plates, as it were able to keep spinning. And so the entrepreneurial side, that more sort of startup mentality, at least to my mind, seems to have fallen away in favor of much more standardized practices and policies, just essentially to try and deal with the workload. But it is interesting that you sort of talk about this as like a kind of neoliberal thing, because it's true that many of these practices are sort of regarded often as being attached, or the organizational arm of neoliberalism is what it's sort of referred to sometimes. And that is certainly true. And you see that playing out a little bit in the way that the court is funded and how sort of stakeholders are treated as kind of investors and shareholders and so on. But it's also got a much longer history as well. So you definitely have this turn in the 70s and 80s with new public management, but you also, even before then, have a lot of management tools being adopted in the United Nations, where it seems as though they were often being used there as a kind of one front in the struggle between the global north and the global south
Mm.
in relation to the new international economic order.
Yeah.
And even before then, you see it planning out in other places as far back as the American plantations of the pre-Civil War period, where management seems to kind of have found it really came together at that point to organize people and space and so on. And you see it kind of having an effect right up to the present day. And many of those practices from that time were also visible at the International Criminal Court. So there's a kind of very long history here.
Yeah, and I absolutely love that chapter of the book, and I think that I probably made notes of the entire chapter when I looked at, the issues when it came to the NIEO, and also looking at the ways in which you kind of trace it back to the Western European American experience of governing spaces. And so from the management of slavery through to the plantation, to the organization of war, and the running of the American factory. So to what extent do you think that the fact that the court is self-funded contributes to the impression that it is a way in which empire continues to manage the third world? Because I found that bit really interesting, and it's also something that I had no idea about before I read your book, and it's not something that I had thought about. But in terms of it being this neoliberal management exercise, then where the funding comes from is then the most important.
Yeah, I think actually, if you think about management not so much as just a set of kind of scientific tools, but as quite historically situated set of languages and techniques that are part of wider political struggles, then it's easier to, as you say, identify these stakes, identify the fact that, oh, it turns out that management might actually prefer certain outcomes over others, or it might be put to certain
Mm.
uses versus others. So that example of the funding regime is one of them. Of course, the ICC, like many international institutions, has to get its funding from somewhere.
Yeah.
And the model that they ended up with was to have a self-funding regime. So states parties would fund it. There would be some room for voluntary contributions, but mostly it's states parties, members that fund it. And that wasn't necessarily a consensus early on. States from the global south wanted a court that was funded through the United Nations system. And that's partly because they were afraid of powerful states withdrawing and leaving other states then with a larger bill.
Right.
And also because they were a bit concerned about whether there would be some level of manipulation or trying to influence the court by using your own finances as a wealthy state
Mm.
to try and prioritize certain things or to get the court to do what you would want it to do. And in the end, the states did agree to this self-funding model. And that was because global South states got these assurances that larger states would be part of it. In the end, as we know, the United States did not sign up, and they kind of, the last minute, decided not to sign the Rome Statute, which already caused some issues. And now I wouldn't say that we have a situation like what happened at the UN in the 1980s, where the US, for example, was using its financial position to basically say to the UN, you must do this, you must, or we will withdraw funding.
Right.
But because because some wealthy states have, of course, a very large piece of the pie that they're contributing, they often are able to say that the court should try to be more efficient or have a much more value for money mindset in its work. And this happened particularly after 2008, the global financial crisis. There you see a lot of their interests, which is to make the court work more efficiently and so on, with less money, as being prioritized. which is kind of a similar set of outcomes to what you did see happening at the UN in the 80s. So that self-funding model has, I think, contributed to a much more managerially minded court that's concerned about, yeah, spending the money well in order that it doesn't, fall on the wrong side of some of its members. And those members, of course, are largely the members that have the money, and not so much those that are less wealthy.
And I think it was interesting to read about that, given we have a culture of immense cynicism about the court, not only being from South Asia, a region which has largely not accepted the International Criminal Court, but also um, being from an Islamic state, and most of the Islamic world has also not accepted it. And I think it was really interesting looking into how these highfalutin, lofty ideas of justice are undermined by this supposedly apolitical notion of management, which also distracts from the real question of what justice would look like. And that's something that is coming to the fore, especially now, given that we have arrest warrants for Putin and Netanyahu. I remain very cynical about the court, even though there's the Pakistan generally and this part of the world is now, it seems quite pro it because we've got an arrest warrant for that. But I'm most interested in how this comes about when we look at questions such as the deprioritization of American crimes in Afghanistan, because you talk about that in the book from the perspective of the pretrial chamber and that decision. And then we had another one in 2021 by the new prosecutor, Karim Khan, deciding to deprioritize American crimes. So do you think that decisions such as that too were affected by management ease?
Yeah, I think they were, unfortunately. So I think that is one of the, as I mentioned at the very beginning, one of the most concerning, I think, aspects of management for lawyers.
Mm,
And this is not the first book to try to link management to other things that it might be deprioritizing, like fairness or like human rights or something. I mean, lots of people are talking about the effect that that technocratic language
yeah.
has on whatever it might engage with. And at the ICC, I think we saw this in the pretrial chamber decision in 2019 when the court decided it wouldn't open an investigation into Afghan and US crimes. And the reasoning was this interest of justice approach
Mm,
test, which is quite broad, but they were trying to say that it wouldn't be in the interest of justice to open that investigation because the court's organizational stability essentially was at risk. It wouldn't have the resources to be able to engage in that investigation properly. And the background of that, of course, was that the US would not cooperate largely with that investigation. That was then overturned on appeal, allowing the prosecutor to go ahead. And then, as you say, 2021, the prosecutor then says, looks like we really do have an issue around investigation. So I think they actually had the precise wording that the prosecutor used, and again using this idea of limited resources that
mm,
are available to the office, which, to be honest, is exactly the same managerial rationale that the pretrial chamber was using not to open the investigation initially. So in some ways, it's almost as if the pretrial chamber was sort of quite prescient. They did predict correctly
right.
that this probably wouldn't work out. But also it's clear that that managerial rationale is working its way throughout all aspects of the court, not just in the pretrial chamber, but also potentially into the decision making of the prosecutor and in other organs. And I think that's confirmed by quite a number of years of that management rationale being important in the organization and in other areas of the court's jurisprudence. So to me, it seems consistent now as a move. And of course, many lawyers will critique it severely for being extra legal, potentially
Mm,
even politics by other means. So yeah, it's quite a clear development there.
right. Yeah. And about the chapter on the micromanagement of the court, how do you think that the ICC's human resource policies, and I thought it was so interesting to see how the job descriptions are actually written and what was advertised. How do they use that notion of efficiency to engage in managerial practices to optimize individual performance in a way that you argue that it narrows employees' professional imagination? So how does that work in conjunction with what we've been talking about?
Yeah, so maybe I begin by saying that I think a lot of people anyone who's engaging with the ICC, whether it's you and me or people who might actually be victims of crimes that the ICC will investigate, or whether it's civil society organizations or whoever, all have quite specific ideas of what justice is, of what justice would mean for them. So for some people, it would mean one thing, for others, it might mean
Hmm.
something very, very different. And I think what's interesting is that in the process of being kind of professionalized as a person within the ICC, as a staff member, a very specific idea of justice as being essentially ICC centric, as being very institutionalized, very much driven by experts largely based in the global north. That is the version of justice that gets reproduced through all of these kinds of techniques and processes.
Hmm.
And they begin actually outside of the institution. So if you're thinking about, applying to the ICC as a professional, like many of us do when we're applying to a job, you're trying to imagine yourself into that place and to then show that you're competent as a person who would fit into that space. And that process of kind of self-disciplining or self-regulation to make yourself a kind of professional fit is also essentially shifting or constraining certain professional ideas of what justice is and what your role is as a professional. And in many ways, it kind of hides or closes off other avenues for doing justice, for thinking about
Hmm.
what justice might entail. So if you're very much focused on achieving certain small tasks within a very short time frame, as many professionals at the ICC are, then the ability to then think more complexly across certain different levels or across different cases about what justice is and what it might look like for victims or other groups is really difficult to achieve because efficiency and so on are really, really the bottom line, as it were. So that is kind of what I'm trying to trace in that part in that chapter through this ethnography of documents, essentially.
Yeah, and I think it's interesting because I've been reading a few books which are heavily critical of international criminal justice in and of itself as this kind of retributive mode of justice. And they kind of talk about this kind of weirdly over specialized approach that the West has towards things, but also the things that are neglected when we look at retributive justice and criminal accountability as it should take place. And I think it was really interesting as well that at the end of the book you favored this strategy of rupture. And we've seen criminal trials being used to further ideas by those that they sought to hold to account, such as Hermann Goering, Slobodan Milosevic, and Saddam Hussein. So how would this strategy work for those outside the court who are looking in and who are unhappy with what they see, especially when you're coming from the global south? And presidents of Kenya have called it the International Caucasian Court. That looks to be changing. The impression of it has kind of changed now, given an ally of the West has been given a arrest warrant. But we still have that quite deeply entrenched in our political imagination about the ICC.
Yeah, so I think, this strategy of rupture was an idea. It's been around for a long time. French-Vietnamese lawyer Jacques Vergès had essentially looked into trying to think about a courtroom trial, not simply as a way of defending his client, but as a way of putting forth an alternative political narrative
Mm.
to the state narrative, which of course is represented by the prosecution, in order to say firstly, to reject the authority of the court, which you often see people doing, like Slobodan Milosevic,
Yeah.
quite vocally doing this, but also then to say that the other side, which is the prosecution, is not an apolitical stance, right? It's a political position that is sort of written in legal terms. And of course, when you think about the management side of the court, that doesn't really map on that well because, no one's doing that kind of rupturing at a small managerial level. And so this idea of a strategy of rupture, I frame more as discomfort. So
Yeah.
one of the most common things that I found at the ICC was that this resort to management and the resort to reform was a deeply, deeply comforting kind of salve for professionals in all sorts of ways. And it was allowing them to continue to do their work, perhaps to dampen critique, perhaps to forget about failures that had happened in the past, because there
Right.
was always this sort of promise that there would at some point be an improvement. We would learn
Mm.
our lessons and so on. And that to me was a very comforting move, which had a lot of problems with it. So then I'm kind of saying, well, maybe a strategy of discomfort would be necessary. That might look very different from inside the court to outside the court. And outside the court, I'd say that it's quite a situated kind of practice. There isn't one clear answer to this, but if you were a teacher of international criminal law outside of the court, then maybe it would be worth thinking about the other visions of justice that it might be possible to have that aren't so institutionalized, that don't come from, one place in Northern Europe, and that aren't driven by very professionalized experts who have largely been trained in the West.
Yeah.
So that would be one example. Another would be that if you're a researcher of international criminal law, it's very easy to, I think, get caught up in the spectacular side of the field, the stuff that's always in the news, the stuff that you want to know more about,
Mm.
but which is very short-lived. And actually, by doing an analysis here at the more everyday level, at the kind of mundane level, things that change but change quite slowly, I think you end up getting quite a lot of insight from the way the court works and people's experience of management. Because, sure, victims have an experience of the court in the courtroom, but oftentimes, victims' first encounter with the ICC is either through a person that's been sent there to their community to talk to them, and then through one of these application forms, which are very kind of
Mm.
managerially organized and now I think are only one page long for efficiency reasons.
Yeah. Yeah.
If we kind of engage with those more technical details, I think it might be easier to then figure out what the stakes are. Who wins, who loses from that kind of interaction, whose voice is being amplified, where is the money going? All of those kinds of questions become easier to answer when you look at the management stuff and you think more about discomfort.
Yeah, and I thought it was such an interesting angle that the entire book took. And I had taught international criminal law at the university here at the start of the year. And I was so wishing I'd read this beforehand because I thought that it would be so good to have had a session or like, at least an hour of one of the sessions talking about this it was such a practical perspective, but it's also not one that we get so bogged down in the case law, we get so bogged down in not looking at the institution from this lens. And I really, really enjoyed reading the book for that. And especially looking at the ideological underpinnings because everything is enshrouded in ideology. And when someone tries to tell you that it's not, I feel like there's more ideology baked into that assumption
Yeah,
than not.
yeah,
So thank
very
you so
often.
much for writing such an important book.
Thank you. Yeah, I really appreciate the positive review there.
Thank you so much for watching at home, and we hope you'll tune in for future episodes.